Hi, everybody. It is now 12 o'clock here on the East Coast of the United States. And you know what that means? The Zoom at noon, time for Garden State CLE, lunchtime learning. When everybody would just follow through with his lesson plan, we can go to the beginning. And the starting point, of course, is going to be the two constitutions, the New Jersey Constitution and the United States Constitution. Let's start off with the federal and state constitutional authority in your materials. Article 2, Section 2 of the U.S. Constitution. The president is vested with pardon powers as follows. Now, the language here is very important. And he shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. So you see now that there are limitations and expansions of power here. Number one, you have to distinguish between what is a pardon, which is really kind of complete forgiveness for a criminal offense, and a reprieve, which has been interpreted by the courts to mean commutation of sentences, modification of sentences, and things of that nature. Two distinct powers constitutionally given to the president. Limitations on it are, number one, that the pardon power can only be used by the president for crimes against the United States, federal crimes. So the president has no jurisdiction to pardon anybody for any type of state offense. And finally, there is an exception here, which we'll get into why they have this in here, for impeachment. The power of a pardon does not extend to impeachment. All right. Let me read over the commentary we have here, because I really want to talk about this a little bit. At the time of the founding era, the authority to grant pardons had been vested in the King of England for centuries and was well established in the common law. And there's a discussion of that in this 1855 case, Ex parte Wells. I really want to talk about this for a couple of seconds, because the framers of the Constitution really did not spend a whole lot of time debating or having any serious discussions about the pardon power. It was something that had been so well established in the common law at the time of the founding for decades and decades and decades that the lawyers of that era really just kind of accepted it the way it was and didn't really feel any need to modify it. There were a couple of at the Constitutional Convention, there were a couple of minority plans that were submitted. One was, I think, called the Virginia Plan. The other one was, of course, the New Jersey Plan. And since it was from New Jersey, it was roundly rejected. At the end of the day, the framers determined that they would basically copy the model that had been part of the British Constitution going back hundreds and hundreds and hundreds of years. And they used the model that had been primarily exercised by Henry VIII. Henry VIII made it his practice to pardon individuals without any justification at all, and was not cowed or in any way influenced by the acts of Parliament. See, it's interesting because the English Constitution is not a written document, and as a result, Parliament in that era felt that they had the authority to go in and modify the pardon power that the king had. The only real modification that they did, which stuck with the law, was removing the ability of the sovereign to grant pardons for impeachments. And that, as you can see, became part of our common law in the United States. Prior to the founding and during the founding, this was adopted by the framers and placed into Article 2, Section 2. Okay, so those are the only limitations on there. And notice that there is no authority of any body to restrict, limit, hinder the president's power here. It's really just plenary. Okay. Now, let me see what else I say here in our notes. The pardon power provision in the Constitution is directly related to English common law. Note that the plenary power does not expressly provide for reprieves and remissions, but that practice has been deemed to be in the case law to be implicit in the pardon power. Okay. And the use, again, the word reprieve in here should be very broadly construed and has been so perceived. There's been a recent case that came out which further expands the pardon power. It's a case actually from this year, Trump versus the United States. And I think you're all familiar with the holding in this case, which provided that the president is absolutely immune from actions that he takes in his official capacity. And one of the arguments that came up and was discussed in the law is, well, what happens if the president grants a pardon, and there's some evidence to suggest that the president in granting such a pardon had a corrupt motive, maybe bribery or something of that nature. And the Supreme Court held you can't look behind the motives of the president in granting a pardon. The president's authority is plenary and not subject to review. because it's part of his official duties. Again, the ability to grant a pardon. So the idea that even though the president may have a corrupt motive in granting a pardon, it's not going to hinder his ability to grant the pardon based on this Trump decision from earlier this year. An amazing decision. It's really unprecedented in American law, but it really directly impacts on the pardon power. A couple of things in terms of the broadness of the pardon power, just a couple of issues that come up. This is one that's also in play these days. Pardon power can be extended to a criminal conduct that has not yet happened, okay, in the sense that no one has been charged, indicted, or things of that nature. So these are the so-called preemptive type pardons. That was explored by the United States Supreme Court back in 1866 in a case called Ex parte Garland. And the court ruled that the pardon power is so plenary that it can be utilized for people who have not been charged officially. They may be under investigation, they may not be. It doesn't make any difference. So there's some talk these days about preemptive pardons for people who have served in prior administrations or had prior dealings with the federal government. And the question is whether or not the president can pardon individuals for conduct that has not been subject to any charge yet. And the answer is a resounding yes. I think the best case historically where this came up was the pardon of Richard Nixon by Gerald Ford, where President Nixon was pardoned for any and all crimes he committed or may have committed during the time covered by the pardon. And at that point, President Nixon hadn't been charged with anything. Now, he conceivably could have been indicted and charged with all manner of federal offenses, but the pardon put an end to that well before there had been any formal prosecution taken, no return of an indictment or something of that nature. So the case law supports the president's authority to do that. By the same token, the president does not have the authority constitutionally to pardon somebody for a crime that may be committed in the future by somebody. That's just something that the courts won't allow because it provides an immunity, a general get-out-of-jail-free card to anybody for any type of act that would be committed in the future. So the pardon power is plenary. It can be retroactive, preemptive, but not in advance, in the sense that you can't pardon somebody for some crime that he's going to commit in the future. Okay. Here's an interesting one. I've seen this mistakenly quoted. Here's the question. Does an individual have the right to reject a pardon? And for the longest time, I thought, yeah, why not? So the bottom line on all this is that, yes, you do have the right to reject a pardon. That comes through the case law. United States versus Wilson, all right, and a fairly little bit more recent case, Burdick versus United States, 1915. But in both of those cases, the defendants who were subject to presidential pardon said, I don't want your pardon, I reject your pardon, okay? Because the pardon implicates or implies that I'm guilty of something, and I didn't do anything, okay? And I guess that gives you your opportunity to vindicate yourself before a jury and see if the jury agrees with you. There's some interesting sidelights, especially in the Wilson case. Wilson was going to be charged with mail robbery, okay? And he had a co-defendant who was also charged with the same thing. And the things, as it wound up, the co-defendant was prosecuted and wound up being hanged. It's not clear in the law whether or not Wilson was ever convicted of anything since he rejected the pardon and wound up being hanged himself. So it's not clear about that at all. Some sources say nothing ever happened to him, and others say that he was subject to the death penalty. I don't know the answer to that, but it's interesting. But the case stands for that proposition that if somebody is subject to a presidential pardon and that individual doesn't want to have the pardon, the individual has a right to reject the pardon. And I know there's been some discussion about that, especially among some of the people who are in the political sphere over the last 5 or 10 years during the last two administrations, one of whom said, I don't want any pardon from anybody. I didn't do anything wrong, and I don't want any imputation of any wrongdoing by me. And that's perfectly fine. You have the right to reject a pardon. All right.
And you have the right to be hung.
Oh, okay. Hey, Joey, how you doing?
I had had to update my Zoom app. It's been a while.
Joe, I got to ask you a quick question about the history of pardons. It seems to me, from looking at the case law, reading over law review articles, that the framers of the Constitution really didn't take the pardon power that seriously, in the sense that it was so well established in colonial law so well established in British common law at the time that they didn't really, it wasn't a controversial thing. Is that your impression of the history of this?
Yeah, when we go into the notes by Hamilton of the Constitutional Convention, there were those who wanted this to be spread the power to grant immunity for or pardon should be spread among the Congress and the Senate and the executive branch. However, Hamilton was clearer that once you get too many people involved, there's going to be too many problems, and that one man who will be speaking solely on behalf of the government, and knowing that his own reputation will be soiled if he doesn't make the correct decision that people could easily agree with. It should be in the executive, the chief executive of the United States, the president. And it turns out that from that time on, from that Constitutional Convention, that was the language that was sent to all of the colonies to adopt their own constitution, and in all of those colonies, there was nary a peep or a response that they did not want it that way. They wanted it to be the executive. Now, Connecticut and Rhode Island still grant the power among all three branches of their government, but not the rest of the states.
You know, Joe, it seems to me that I always go back and look at the lawyers who were around in the founding era, and they certainly were aware of, and I want to call it the Henry VIII model, of the absolute power to grant pardons without any restrictions at all, with the possible exception of granting pardons for impeachment cases. And when the colonies were established by England in the United States, I'm talking about, you know, the colonial governors that were appointed here, it seems to me that every one of the 13 colonies had some mechanism for the governor to grant pardons, again, during colonial times, pre-Revolutionary War times. So it seems to me that the law was so well settled and the people were so used to this power that there was really no serious question raised. I mean, nothing, it was not controversial at the time of the founding. Would you agree with that analysis?
Well, there was two anti-federalists who led the charge to want to spread the power among, the Congress, the Senate, and the president. But nary, when it got to each of their own constitutional conventions, whether they would accept the United States Constitution as having been circulated, there was no dissension at all. Everyone adopted it just the way it reads today.
Well, we've had, just to move over to New Jersey for a moment, we've had three constitutions in the history of our state. The first, 1776, was necessitated because of the Declaration of Independence and breaking away. We had to have our own government and our own founding document. That constitution was in effect until 1844. And then following that, that stayed around for 103 years. And now we're currently under the 1947 Constitution. But each one of those constitutions had some mechanism for the governor to grant pardons. The 1844 Constitution, the one we have today, the language is almost identical in a lot of respects, but the pardon power is pretty much the same in both. In the 1947 Constitution, it's set forth under Article 5, Section 2, Paragraph 1. Let me just read it so we can go through the elements of it. The governor may grant pardons and reprieves in all cases other than impeachment and treason, and may suspend and remit fines and forfeitures. Now, notice how the parallel here between this constitutional grant of authority on a state level and the federal grant of authority. Notice the governor may grant, so it's a discretionary authority, pardons and reprieves. Same language, same power that's in the United States Constitution in all cases. So I guess it wouldn't matter whether, it's what the charge was in New Jersey, other than impeachment. Again, the same limitations that's in the United States Constitution. But here, they've also added treason, and may suspend or remit fines and forfeitures, okay? Now, forfeiture here has been very interesting because it comes up with, in the context of forfeiture of public office, okay, where you've had people who lost their jobs because of some criminal conviction in the government. And what is the effect of a pardon on these individuals? Can the governor's pardon restore that individual's civil rights such that he can run for public office again? So notice that there is a broadening here in New Jersey beyond what's in the United States Constitution to include treason. and the suspension of fines or the remission of fines and forfeitures. Again, additional powers extended to the governor of New Jersey, which may be impliedly contained in the United States Constitution, but very specifically set forth in the New Jersey Constitution. Okay.
Now, doesn't it refer to the Constitution or the subsequent legislative actions? Don't they call it clemency in New Jersey as opposed to pardoning?
They do, Joe, and I want to get into that a little bit because clemency is just a broad term that subsumes the idea of pardons, but also other types of relief, sentence commutation, changing a sentence, remission of fines and forfeitures. Okay, so when we talk about clemency, we're talking about the broad spectrum, but there's distinctions between the different types of clemency that is granted. Let me just read what's in our notes, and I want to talk a little bit about it. New Jersey pardons and reprieves are subsumed under the general category of executive clemency. It appears to be the case in the decisional law that a pardon relieves the guilty person, of civil and criminal burdens of the crimes forgiven, so that the legal disabilities of the consequences from the conviction are removed. Okay, and this goes back. I guess it's an old county court case, but it's been cited with approval by the Supreme Court several times. Ex parte Fitzpatrick. Okay. It's later affirmed by the appellate division. And we'll get into the actual practicalities of what that means, okay? So that's what the pardon does. The other types of executive clemency are important, but they do not remove the criminal conviction and do not necessarily restore the rights that you get once you've been pardoned. Here is the explanation in your notes. The result of an exercise of executive clemency is typically found in sentence commutation, reprieves, fines, suspensions, and the remission of forfeitures. Unlike the pardon, the criminal conviction and its disabilities remain with the exercise of executive clemency. So it's only the pardon that restores you and gets rid of the crime. Everything else, the crime stays, although some of the relief that you get may be extremely important to your life, okay?
And Bob, it's also interesting that although a pardon wipes out your conviction, there's nothing on the record to suggest that you were convicted of that offense. The fact of the incident itself, all of the facts that swirl around it, suggest that, yes, you were deeply involved in this. They're giving you a break now, even though they believe you probably did it. So if there is something, for instance, like a pension, a police officer with a pension, even though the pardon has exonerated him from any conviction, they would have to take into account whether or not his conduct was within the bounds of what would be expected of a police officer. And in that situation, that bad character is still out there. It's just not of record as being the subject of a conviction.
No, I don't know that, and I don't want to be a nitpicker here, but I'm not sure that the word exoneration is correct in the context of a pardon. It's basically you have been forgiven. No one has said that you're innocent, okay? Which is why some people want to turn their pardons down, because look, you're imputing guilt to me, and I'm not guilty of anything. But when you say exonerate, that's the jury came back and said not guilty, or the prosecutor's office said we're dismissing the charge against you. You didn't do anything, okay? Pardon doesn't exonerate anybody. It's the forgiveness. It's a matter of pure grace